Is it possible that when you bring a lawsuit, let's say for medical malpractice, that the defense never, ever offers you a single dime to try and negotiate? Is that a possibility? You want to know the answer? Come join me on my walk to the train this morning as I head into work, as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It's a beautiful, crisp day today here in Great Neck, and I wanted to take a moment to share this great information with you. Okay, so let's say you brought a medical malpractice case against a doctor whom you believe was careless, and you believe that his carelessness caused you significant harm and injury. You believe in your heart of hearts that your case has a very significant value, that your damages are extensive and permanent, long-lasting, disabling. And as a result of that, you believe that the defense should immediately recognize that your case should be settled shortly after you start your case. You are curious why, after months and months after starting your case, the defense does not approach your attorney and does not attempt to negotiate your case. You are wondering, after an entire year of litigating your case, why the defense has not started to negotiate. Now, you're approaching the 2-year mark. Your case is being litigated and hard fought. The defense is putting up every obstacle possible to try and show that you do not have a meritorious case. And you can't understand why the defense has not offered up a single dime. And there's a reality here. The reality is that the defense, the doctor, the insurance carrier, their experts, may have come to the conclusion early on that your case did not have merit. They may have come to the conclusion that the case was defensible, meaning that they believe that your case has no merit. In that instance, they may take the position that they would rather go to trial. And now let a jury, 6 members of the community, make a decision about whether you are slightly more likely right than wrong than what you are claiming is true, meaning that they believe that their case will outweigh yours and that the jury will side in their favor. In that instance, you have a significant uphill battle. And now you are trying to understand why, if you and your attorney and your medical experts have all concluded that you do have a valid and meritorious case, why doesn't the defense see it the same way? And why haven't they started to negotiate? Because you've heard that the majority of these medical malpractice and accident cases and wrongful death cases settle before trial. Now, there is one thing you should know. At the very beginning of your case, it is quite possible that the defense is at a significant disadvantage. What do I mean? I mean that they may not have sufficient information in order to make an educated decision about whether or not you actually have a good case. Now, why is that? It's because at the very beginning, they will not have all of your medical records. At the very beginning, they won't know all the details of your case. At the very beginning, they will not have had an opportunity to have an expert review all of your medical records, just as your attorney has already done to confirm and validate that you do in fact have a good case. So that may be one of the reasons why at the very beginning, even though you believe and you know that you have a very good, strong case, the defense is behind the 8 ball and they don't have all those details and they don't have all that information that they need in order to make an accurate assessment. That may force you to go through the litigation process. So now, as you go through the litigation process and you get closer and closer to trial, you may be wondering, why aren't they offering you any money? What's the problem? What's the holdup? I'll tell you why. The defense may have reached the conclusion that their case is defensible. They may have come to the conclusion that their case is stronger than yours, in which case they're willing to roll the dice, go to trial, and now let a jury decide whether you are able to show that you are slightly more likely right than wrong than what you are claiming is true. That they believe that the doctor did nothing wrong. They believe that whatever he did not cause or contribute to your injuries. And even if it did, they may feel that those injuries are not very significant, in which case they may decide not to offer you a single dime. So why do I share this information? I share this information with you just to open your eyes and to help you understand how the lawsuit process works here in New York. And don't think for a second that just because you believe you have a great, fantastic case supported by medical experts, that automatically means that the defense is going to see your case the same way you and your attorney does. And don't think for a second that just because you think your case is worth X millions of dollars, that the defense is also going to recognize that same evaluation. And even if they do, it doesn't mean that they're going to offer you any money, certainly at the beginning of the case. And now as your case progresses and they learn more and more information about the details of your case, it doesn't necessarily mean that they're going to go ahead and accept your version of the events and accept the fact that they are now at a risk by going to trial. And if they go to trial, they may come to the conclusion and the opinion that they will be the victor. They will win when now the case is presented to the jury, and a jury will have to decide who they believe. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.